Hi, this is Shivansh serving as legal intern at LEXIS and Company. Today we will discuss the concept of treaty. Treaty, in common parlance, may be defined as a written agreement between parties which may or may not be stated to identify and follow a set of rules. They may also be referred to as pacts, agreements, charters, etc. Declarations and political statements are excluded from the scope of the definition of the treaty. Treaty have been classified on the basis of many principles. On the basis of the object, they have been classified as political treaties, including alliance and disarmament treaties, constitutional and administrative treaties. Example, WHO's constitution, which is responsible for setting up the international body and to regulate its affairs. Commercial treaties, trade and fishery agreements, criminal treaties which define certain international crimes and may require the offender to be extradited. Treaties codified international law and treaties for ensuring civil justice. A country that hasn't signed the treaty has no obligation to follow its norms. However, like the ICJ has stated in the North Continental Shelf cases, that some treaties may give rise to the international conduct, customs, and be of a fundamentally norm-creating character. Article 26 of the Vienna Convention on the Law of Treaty deals with the Latin maxim "Pacta sunt servanda," that is, every signatory is to follow the treaty in good faith and is binding upon them. This forms the basis of every international agreement. Reservations are the way in which signatories may escape having to follow all the provisions of the treaty and is a tactic used to become a party by agreeing to the basic principles of a treaty. However, reservations can only be made in case where such reservations is not contrary to the object of the treaty. Interpretation of treaty should be bona fide and the object and purpose of the treaty needs to be kept in mind while doing so. In case the text is vague, another supplementary means of interpretation might be used. One such method of interpretation of a treaty is adopting a broader perspective and a significant constitute broader approach. Consequently, a purpose-oriented approach is adopted in case where the treaty is questioned to be interpreted in the constitutional document of an international organization. Thank you, and if there is any doubt, please mention that in the comment section.